Now, one of the things that we must also ask ourselves is what is the scope of our intervention? Sometimes the parties in a transaction have agreed on a number of items. They've agreed on the pricing, they've agreed on the timelines, and they've agreed on certain fundamental terms. In that sort of a case, your responsibility then would be limited to just helping them capture, in addition to due diligence, of course, capture what the aspirations of a transaction are in relation to their instructions. Very importantly, we must also always, before we jump into a deal, ask ourselves, what jurisdiction is the deal to be conducted in? It's not always the case that deals are conducted in Nairobi. If the deals are to be, transacted, say, in the Orient, the East, what are the fundamental differences between their laws and our laws? Is there any other party? I mean, if you want to be able to introduce a dispute resolution clause, what will be the seat of that dispute resolution? So jurisdiction then becomes an important thing. You may want to, in the context of what you had said earlier about biases, you can imagine if you have a transaction that also maybe pits you against people from different religious backgrounds. It means you must take into consideration those religious backgrounds, so that in your transaction, if for instance it's a lender or a blended finance arrangement, how do you structure your deal in such a way that in the jurisdictions that permit, you can charge your interest, but if for instance you're dealing with a Muslim religious background, then you have an appropriate way of wording or structuring your deal. I remember in a transaction that we did in Djibouti, that was one of the things that almost sent the deal off the table, because we insisted on providing for default and interest on default. But then the language then was the issue, because for them, the issue of how religion interplays even in contracting is very central. And so it's one of the things that you may want to also apply your mind very, very particularly when you're looking at those matters. But now let me come back to what you've asked me. Part of unpacking the people behind a transaction, it has many fronts. Other than for knowing who the actors are, it also helps you to understand the power dynamics in a transaction. The power dynamics often block deals because you've not understood the background, the orientation, or the thinking of an individual. Take an example of a case where you're dealing with an elderly person, a mature African man, a man in his 70s, probably 80s. That person, if there's anything they want from you, it's patience. And you'll have to do the transaction on their terms.
And time.
Yes, they'll tell you you'll come home on a Sunday in the afternoon because that's when my mind will be clear for purposes of having this conversation with you. And if you truly want to help them, then you must understand that that is what they know, that is how they've done their transactions, and it is important to also have that at the back of your mind, because otherwise you become insensitive to how you make them feel in the context of having the transaction. A second item that you may want to look at is what is the position of the parties before you? What is their standing in the society? That helps navigate certain other small things that sometimes we take for granted, but which may help a deal sail smoothly or run into a lot of unnecessary headwinds. Position and individual wills, for instance, would determine your place of meetings, because it may not be all the. Assuming I'm doing a transaction for a judge. Now, getting a judge to come into a law firm may sometimes not appear very appropriate.
Yes.
How then do we agree that we have a place that is clean, that is objective, and that does not raise any form of concerns for anybody? Because judges, like every last one of us, or any other person in the judiciary, are also Kenyans. They want to buy land. They want to buy shares. They want to buy, a house. So when they are engaging in those transactions, who says that they must only buy shares in Kenya? Yet getting them to come to your office might not necessarily also give the confidence when, for instance, your firm has a matter where they appear, Of course, they may want to, declare it, but it will raise those perceptions around bias and whatever else it is. The other issue that sometimes we take for granted is the question of gender. Because whereas we may know, and this is one of those things that I was saying, we may not quite want to document, but we appreciate that in the context of, in our society today, there are people today who, when you get into a transaction, they'll want to have a male-dominated conversation. What does that do to you as an advocate? If, Karen, you come in, sometimes the only disadvantage that will face you in negotiating a transaction is because of gender. And somebody comes in saying, where I come from, women are not known to negotiate deals. So
they don't sit on the same table as
yes,
men.
yes. So that's one of the things that, whereas it is not anything that anybody would want to have, as a standard position, we must always not forget that it could affect a transaction as a silent but very nuanced, for lack of a better word, banana skin. Sometimes it even gets as bad as to get to the skin tone. Yesterday, I was in a matter where somebody was saying your skin tone either provides an advantage or a disadvantage. And this was in the context of an international transaction. So this is an oil company, and they were in the course of buying something from France. Now, one of the things that became very apparent was that the law firm that was involved, on the other hand, was led by an African, very senior, very well accomplished advocate. But in the eyes of the people who are on the other end of a transaction, they're like, no, we're getting into this transaction, but it must be led by somebody from our jurisdiction. Now, the only reason we could see on the table for insisting that that transaction had to be led by that person, because that person was from a completely different background. This is somebody in dispute resolution, not to mean that anybody in dispute resolution cannot lead a deal, but this other person, the African senior counsel, was brought in because of the experience, the exposure, and in fact almost a monopoly in that type of transaction. So you see what I mean by a skin tone advantage. You almost walk into a deal and somebody says, do you want to first demonstrate to us that you understand? Yet somebody else walks into the door and the same client imagines that this person is competent. Well, as advocates, we know that that's never the reality. But because we're dealing with human beings, those human beings have their biases. We just need to have that at the back of our minds, that sometimes the things that make a deal go through or a deal fail is the perception that an advocate, that the clients or the people on the table have as a preformed opinion. Sometimes people would even insist on people from their ethnic extraction, so that is the person who would explain that transaction to them in a language not that speaks to their minds, but which speaks to their hearts, And so those are some of those things that sometimes we take for granted, but they, I would tell you, Karen, from experience, impact very significantly in transactions.